Good evening, this is Prakhar Devnani, and I'm getting frustrated because this is not my first take, not my second, not my third. So now, I'm Prakhar Devnani from BBFNA Section A. My roll number is 2222031. The topic for today is mergers and acquisitions. Coming to the first point, what is mergers and acquisitions? So, in layman terms, it's basically buying and selling of company to one another. So, mergers is the buying part, acquisitions is the selling part. I'm not going into details, but this is just a basic gist of it. Now, mergers can be defined as unification of two players into a single entity. What does this mean? So simply, two competitors come together, they shake hands, and now they have a larger control over the market. So let's say that competitor A has control over market C and competitor B has control over market D. So now both of these competitors shake hands, they get into a merger agreement, and now as a whole, the company, the newly formed company AB has control over market C as well as market D. So these are a few advantages of merger. Now, acquisition is usually seen as negative because it's usually done in form of hostile takeover. What is a hostile takeover? Where the company which is acquired, which is the more dominant, or the company which acquires the other company, they do it without consent or without informing the shareholders or board of directors. They simply buy their share. They simply get a majority shareholding. They buy their shares from the stock market, and they hence they get a better stand in the board of directors, and now the company is in their hands. So this is basically hostile takeovers, and acquisitions in the market are usually seen in this form. Acquisitions are not always hostile takeover, but generally we can see it in form of hostile takeover. Now, as I was saying, acquisitions are situations where one player buys out the other to combine the bought entity with itself. It may be in the form of a purchase, where one business buys another, or a management buyout, uh, or a business buys out all of the assets of the other business. Now, in India, the process of merger and acquisition is code driven. So, as you can imagine, Indian codes, it takes a lot of time. It's a tedious process. Now these processes are explained to us via Section 230 in the Companies Act 2013. Now, Section 230 says, if I were to break down Section 230 into a few simple steps, step one would go that an application has to be sent an application has to be sent by a creditor, shareholder, member, or a company to NCLT, National Company Law Tribunal, for approval of this process of a merger and acquisition process. Now, this application has information has information which is has information under section 230 subsection 1. Along with this application, some material facts pertaining to the deal are sent. If there is some reduction in share capital, we send that as well. If some other necessary disclosures are there, we have to send them as well. Now, step two is NCLT has received the application. If they approve the application, they further go ahead, and NCLT says that they have to call that the company has to call a meeting of shareholders and creditors, since they are the ones who have put their money at risk in the company. The notice of the meeting, the notice of this meeting between shareholders and creditors are sent to members, creditors, debenture holders. It has to be advertised on the website of a company. It has to be sent to the SEBI, and if it is listed, then it has to be sent to the SEBI as well as the respective stock exchange, so that they can advertise this say on their website. This notice has to be publicly advertised one English as well as one vernacular newspaper as well. It has to be sent to central government, RBI, CCI, and income tax authority for 30 days. So that if anyone has any objections, they can come within those 30 days and explain what their objection actually is and why are they objecting to a merger and acquisition. So now going into step 3, they conduct the meeting, and by way of voting of shareholders, they decide uh, they decide whether this deal should go ahead or not. For the deal for this process to pass, or for this deal to pass, you the in the meeting 75% of shareholders are supposed to vote in favor of this deal, and if anyone has any objection, they can simply object. But even to even to make this objection, you need to complete some criteria, right? If anyone can object, then this law makes no sense, because you and I, if people who don't have interest in companies' affairs are objecting, then that's just making the functioning of the company more difficult. So if you have to object, you need to have 10% of the debt taken by the company. Now, in simple terms, this means that if a company has taken, for example, 100 rupees worth of debt, so you should be the creditor from which they have taken 10 rupees worth of debt. So do you get the correlation how if you want to object, you need to be the creditor which has given 10%, at least 10% debt to the company. If not, you need to be a shareholder which has at least 5% stake in company's shares. Now, uh, our section 230 ends here. Section 231 is about the power of tribunal to enforce arrangement of section 230. So basically in India, the jurisdiction according to Companies Act 2013 has given tribunal certain powers. Now tribunal has the power to supervise and implement this compromise or arrangement, right? A tribunal can give further direction how this process has to go. They can give all the steps in which this has to go. So, for example, if a company is first supposed to pay a sum of their creditors first, then they have to submit their reports, if it has to be done in an orderly fashion, as said by the tribunal, then the company has no choice but to follow that process. If the company were to not follow that process, if the tribunal sees that this M&A transaction is not going as proposed by the tribunal has the power to order winding up of the now. With this sentence, the tribunal can order winding up of the company. You can easily imagine the power given to courts in India. This is where section 231 ends. Coming to section 232, a merger and amalgamation of companies. If the application filed under section 230 involves a merger or an amalgamation, then along with procedures given under section 230, some additional points are need to be given. Now, along with the notice of company, which we saw, which we talked about in section 230, then you have to submit a draft scheme of mergers and amalgamation. You have to submit a report of effect of such mergers and amalgamation on each class of shares. You have to give a report of evaluation. Secondly, while passing the final order, tribunal can make provision to for other required matters. That's it. Now, this is where section 232 ends. We'll be coming to section 233. mergers and acquisitions of certain companies. Now imagine uh, you now in markets mergers and acquisitions happen very frequently, and it's difficult for law for courts to always govern every small mergers and acquisitions. So even for this, Companies Act 2013 has a few provisions. If so, these provisions are given in Section 233, which tells us about merger and amalgamation of certain companies. Now, what does this certain company? What is a certain company? Now, certain company is anything. Certain companies, these certain companies are simply two or more small companies. If the deal is between simply two companies, which are small, they don't have that much say in the market, they don't have that much power in the market, they don't influence uh, anything in that big a way, then they simply can go ahead and merge without them going through the whole process of NCA, going through the whole process as we talked about in section 230. Now, a few steps are given in section 233 as well. Step one would be that you have to invite objection from ROC and official liquidator. So basically, both of these companies invite if there is any objection from registrar of companies or official liquidators. Secondly, you need to have 90% of shareholders approval to go ahead with this M&A. Then step three, declaration of solvency to ROC, which means that company has to declare that it is solvent enough. So basically, they have to, these certain companies have to tell about their solvency status to the ROC. Step four, scheme is approved by 90% of creditors. In step two, we saw how both of these companies needs approval from 90% of shareholders. Similarly, they need approval of these 90% creditors as well. After this, you have to send this M&A scheme to registrar of companies and central government. If ROC has any objection, then within 30 days, they will send a notice to the government, to the central government, making them aware of the objection. If the central government thinks that, okay, the scheme is in public's interest and in creditors' interest, then they'll notify the ROC to go ahead and register the M&A transaction as it is. But if ROC has raised an objection, then central government can ask the companies to first get the approval of NCLT according to section 230. Now, we now I'll present you with some case studies. Uh, Now here we're going to talk about the merger of L&T and Mindtree. Now, as you can see, as I talk, how you are supposed to send under section 230 the notice of this M&A process to SEBI as well as the stock exchange. This is an example relating to similar to the same thing. Here we can see that Mindtree Limited, now known as LTI and Mindtree, issued a public statement which was in regulation with section 3 subsection 1, section 13 subsection 4, section 4 subsection 3, section 15 subsection 2, and section 15 subsection 3 of Securities and Exchange Board of India 2011. Now, this is, if you were to go through this document, what you'll find is that this has all the information relating to the deal. Now, here we can go and see the details of shareholders. As I said, that you need to give the details of how different class of shareholders are being affected. This is where they have given details about shareholders. Now, as we talked about, we'll move on and we'll go to we'll go to the part where LNT, where this merger had an effect on the market. So let me show you. So, okay, here, as you can see, 14 November, sorry. Okay, so this LTI Maitri merger, which I'm just about to show you. Give me a second. Uh, okay, so here you can simply see that on the 14th November 2022, L&T and Maitri both merged into, as we can see, LTI Maitri. Now, we're going to talk about a few effects on the market. You can easily see that the day when LTI Maitri came into existence, the share market was the share market reacted in an extremely positive way, and on that day, this share hit its peak uh, in regard to this year. Now, if we were to see the future trend of the market, we can see a downfall. We don't really see a good bump in the price of the share because the even though the market perceived this M&A deal to be positive, it was not that good for the company. And if we were to take into account the bad times as we were just recovering from COVID during the 2023. Now I'll show you what happened Tata's and uh, when Tata's and JLR. So here you can see that Tata and JLR, they were not merged. JLR, by JLR I mean Jaguar Land Rover. Tata Motors Basic acquired JLR. Now here you can see that it was acquired around June 2008. We don't know the exact date of the acquisition, but here you can see that market didn't really respond that well. We have to take into account that it was 2008 and US had just witnessed an astonishing housing crisis. But after this, we can see an uptrend in the market. Here we can see a downfall due to the COVID, but overall we can see an uptrend. We can see a positive net effect if we were to compare it from 2008 to the current date. This shows us that the even though the acquisition at that point of time might not have received a positive feedback by the market, but along with time, Tata Motors, Tata Motors really showed what they are actually made of, and they basically won the market by the products and services. So that is it for today's presentation. I hope you like it, and we'll meet next time. Thank you.